Today we're looking at IP licenses, agreements and record documentation. So there's a lot to cover in theory, but really all we want to do is think about what these kind of key agreements are, but also obviously for a tech startup, intellectual property is important. So a little bit around the background of that and how you can keep on top of it really, and why you'd want to for a business tech startup point of view. So in terms of intellectual property, it's actually quite a broad range of stuff that applies to companies. And you have to think of it really that almost everything you do in a company is probably generating IP, and IP brings along value. So as a director of a company, you want to be working out how to protect it and safeguard it or right from the start. And even if you don't think of it as valuable, it probably is. Certainly it's valuable to your competition in the sense that almost everything you do, if your competitors could see how you did it, then it would be valuable to them. So you have to go into it with that kind of mindset. So obviously there is a lot of different categories of intellectual property, particularly for a tech-based startup. So the most obvious, or maybe not the most obvious, but one of the simplest is just the simple know-how trade secret. So the more you can keep into your ideas and so on secret, so you would write confidential information on top of documents that might have information that's useful on them, so that people are aware that what's in the business has this value. And know-how is literally knowing how to do something. So you may not take any steps to protect it other than keeping it in-house, but it's quite extensive. So it's obviously technical know-how and scientific know-how, but also just general process know-how, the things you learn in the business about running the processes, looking after your customers. All that is actually know-how that your competitors would probably try and emulate if they could. The trade secret is where you actually keep it a secret specifically. So it could be an ingredient, or it could be a recipe, or a methodology. And you might decide not to patent it, which we'll come to in a minute, but you keep it as a secret. And therefore you need in your company a mechanism for things to stay a secret. So you quite often hear about confidentiality agreements or non-disclosure agreements. So companies often ask their employees to sign these. And this is an undertaking by the employee that they will keep what they learn secret. And in order for them to kind of understand what is to be kept a secret, because it's difficult to say, and you will keep everything a secret, because, what does that mean? That's where you often will see documents with confidential information written on it. And the NDA, the non-disclosure agreement, should say the kinds of things we expect you to keep secret. So things like, the processes of customers, how much we charge or how much things cost, and all of that side of thing. But the problem with a trade secret is if it gets out, that's it. Yeah. As soon as it's out, there's no recourse. You don't have any way of protecting it. So you have to trust your employees. It's a need-to-know basis and so on. Now, obviously, in a startup, there's going to be lots and lots of new stuff being developed. It's like being in a lab here in a science department. Potentially, there's lots of stuff that you would want to keep secret. But other parts of intellectual property that are important. Copyright is, as you'd imagine, it's mainly in our context the written word. So papers, stories, but also your website, marketing literature, brochures, those can all be subject to copyright. Now, you don't need to register that. Copyright is automatic, but you would write copyright on the bottom and a date. That's usually how you see it, yeah, C 2020, and the company name. And what's interesting here, though, is who owns the copyright. Indeed, who owns all the intellectual property. What you want as a startup company or a business is for it to be owned by the company, so the legal entity. Now, that is not automatically the case. Generally speaking, if you employ somebody, then when they're doing work and you're paying them to do the work, their output is arguably owned by the company, but it's not watertight. So you probably, as part of your employment agreement with them, would actually want to state that the intellectual property they generate while they work belongs to the company. And certainly in a tech startup, you do want to explicitly talk about this, because you're employing them probably to be creative and inventive and scientific or whatever, and you want to make doubly sure that that output is owned by the company. The reason it's a grey area is, well, what if somebody's working at home in their garage at the weekend? They could argue they've come up with something new, and it could be based on what they're doing at work. So this is why you've got to be quite careful. And then the big one, if you like, with particularly tech startups is the patent, which is where you obviously write down your novel invention and explain it in quite a lengthy document, just as you do here in the university. In a business, you'll want to be doing the same thing. Writing down any new invention. That's the invention disclosure, where you write it in your lab book or make it sort of logged in time, and then taking that probably to a lawyer, as in an intellectual property lawyer, to then draft into a patent that can then be filed with the intellectual property office. The reason it's really critical is obviously it's going to give you a competitive edge, and in a tech startup, often patents and intellectual property are the key thing, but also it could be what's underpinning your investment. The reason investors want to put money into your company is because they also think that your intellectual property is valuable. So they obviously want it protected, and having problems later in life with the patents could be a real problem. So patents particularly, but all intellectual property can be expensive, so you have to kind of budget for it. You have to have a strategy as to really where are you going to file for protection. In the case of patents, they're by far the most expensive, and that's because it takes quite a lot of money to draft them. Once you file them, you then start to file them in other territories around the world. You may then end up needing to translate them as well. And the more places you file, the more those expenses will go up, particularly as you often need to renew in each territory every year as well. So there's additional fees. In terms of a strategy with a tech startup, the thing with a patent is that it kind of protects you where you are going to sell the product, but also where you're going to manufacture the product. So as a result of that, what you tend to do, particularly if you're cash strapped, is file in territories which are your key markets and also your key manufacturing locations. So broad brush, you would almost certainly file in UK and Europe. That goes, so once you've filed in the UK, it's relatively easy to carry on with Europe. Probably the US, and then places like China, because you will almost certainly manufacture something in China, and China's a huge market. Maybe countries like Taiwan and Japan, if it's electronic type products, because they're big manufacturers of products as well in that space. And then other big markets that are emerging, like India. But as you can tell, Korea, Taiwan, Japan, China, India all require translations. So they're quite expensive. When you as a company own intellectual property and you can actually say what you own, you can list it, then you are adding value to the company. And that's a really good argument then for raising the value of the company in the investor's eyes. So if you can say we've got 2 patents that have been filed, maybe another patent that has been examined and has been granted, then if those patents look substantial enough for the markets you're tackling, then that's real value, because you're actually stopping your competition from being in that. So they won't have what we call the freedom to operate. As a result of that, you will therefore be growing this portfolio of intellectual property. And once you start maybe having some trademarks as well in various countries, then you can see that your brand and your IP has real value. But also this value can be extracted through licensing. The key thing about licensing is you're kind of giving permission to someone to use your intellectual property, or indeed you're licensing in intellectual property, so you're getting permission from someone. So a license is a really good way of monetizing what you're doing. If you in-license something, that's where you're bringing the patent from somewhere else into your company as a license to use. The example would be in a university spin-out. So university work results in a patent being filed, for example, at Birmingham Enterprise. They've filed the patent and started paying for it. They are, like many universities, unlikely to transfer that patent to a new company, but what they will do is license it to the company. So as a result of that, you might pay the university for the privilege of licensing in what may have been your own, in effect, intellectual property that you came up with. But equally, if you hold intellectual property, you might out-license it to other people. So you, simplistically, to a manufacturer, to make what you've come up with. It may be so expensive for you to buy all the equipment and manufacture in-house. Let's, for example, say you've come up with a nanotechnology-based sunscreen. You probably wouldn't manufacture that in-house, but you might go to an external manufacturer or a brand and say, here's the license, you can go and make it, and you pay us royalties. The key is to get these terms down as to what you want in a license and try and do that with a negotiation, but not involving expensive lawyers. In a university like this, there will be a template that the university, through its experience, will have worked off before. So almost certainly if you went to somewhere like Birmingham Enterprise and said, we're going to spin off, we'd like to license the technology, they would hand you their template, say this is what we work off. And then it's up to you to obviously understand it, but then still negotiate. Everybody has a different technology or product or service that they're wanting to develop. But certainly if you can start off with a template, that obviously helps. And the reason you've got to be careful is, apart from anything else, eventually it's going to probably be drafted by lawyers, and that's going to involve expense. As a startup, you'll want to keep your costs as low as possible. Always negotiate. Everything is negotiable. And what gets handed to you will generally be in the favour of the other party. They're not going to give you anything that gives away too much. So even in a situation where a university is trying to help you spin off, you can rest assured that there will be terms in there that benefit the university. They'd be silly not to. So it's up to you in that sort of situation to look at getting some clauses in that benefit you as a company. It's amazing how many people sign agreements without reading them, or without understanding them. So you should go through each clause and try and understand what they mean. And I've put there what survives. So the other thing that's a big issue with agreements is that often you can terminate an agreement and it ends, but things carry on surviving, is what that is the term there, afterwards, which means you're still responsible or you still have liabilities even if you've stopped the agreement. I mean, that can be simple things like you will still owe us the money that you owed us after the agreement's terminated. So you can't just terminate agreement and not owe any more money. But also keeping things confidential. That needs to survive after the agreement is terminated and so forth. And sometimes agreements aren't very easy to terminate, and license agreements are one of these things. Think about it first of all from your side. What if they, the licensor, the university, wanted to terminate the agreement? Well, that's not going to be any good to you if you've just invested millions of pounds in developing the product. So it almost needs to be not terminable.
There's some serious risk associated with building a company based off someone else's patent.
So it should not be possible for them to terminate the agreement without real cause. For example, if you owe them a lot of money, or you've brought the university into disrepute through some issue. So you need to look at that. What you don't want is a nice agreement falling away out of your control. But equally, you will want to terminate in certain circumstances as well, particularly if for some reason it just does not work. You can't make the business run. The last thing you want are ongoing royalty payments and so forth. So you've got to look into that and try and understand the liabilities as a result and what could and couldn't happen. So lawyers can certainly help walk you through all of this, but often, it's written in English enough for you to get a feel for what could be going on. The commercialisation arm of a university might take equity because they know that the startup has no cash. The startup doesn't want to be paying cash. So it's a negotiation as to how much equity is involved. And the good thing about that is that if the university, for example, has equity in the company, there's instant alignment. They want to help the company. If the company is going to go big, it's great for the university. So if you think about it, when you have these sticky situations in the future where you might owe the university some money because of a cash flow problem with the royalties, you can go back to them and say, look, let's have a little payment holiday for a few months while we sort ourselves out. Don't forget, you've got an equity stake in this company, so it's worth you hanging on in there. So you can twist it into a useful negotiating tool. The flip side is don't give away too much equity. Sometimes these commercialisation arms can be a bit greedy and want lots of equity. Another key point is around exclusivity. So exclusivity means basically no one else can use that technology if you have the exclusive license. Now, there are actually degrees of exclusivity, so it could be complete entirety. Nobody else can do anything related to the patent. But more likely it's exclusivity in certain fields, like aerospace or automotive, or in certain territories, like the US or Europe and so on. What you have to watch, though, is you as a startup probably don't know exactly how it's going to change over time. So you as a startup want to probably go for as greater sort of scope of exclusivity as possible. And you need it to be exclusive because you don't want competitors coming in and licensing the same technology, even if you've helped invent it. You obviously don't want competitors using the same stuff, and investors won't want that. Investors won't invest in your company if someone else can come along a couple of years later and license the same technology that you've just been saying is really valuable. So exclusivity is really important. It's all very well taking the patents and licensing them into the company, but a lot of other stuff may have been developed in the labs that hasn't actually been distilled into a patent, which is a good example of know-how. And you want to make sure that you're allowed to use that as well. Whether you're allowed to sub-license or not is important, because you may want to actually use the IP that you're licensed in to then allow someone else to manufacture. So you don't automatically have the right to sub-license. And what you don't want is your sub-licensee going back to the university, for example, and having to negotiate all of that again. Important one here is successors and assigns, which is what happens if you manage to sell your company. So you exit the company and sell it on to someone else. That's probably only going to happen if the license agreements also can be transferred. So in some of the earlier sessions, we've talked about obviously the roles within the company and the departments and kind of who knows stuff and how it's arranged. So clearly, as you probably gathered, some of this stuff is so sensitive that probably only the board will know all the details about it. Yeah? The upper echelons of the company that are responsible. So shareholders agreements, license agreements. I put shareholders agreements here because they're also agreements that are a little bit structured a little bit like a license agreement. They have all these sort of terms and so on. But those kind of agreements will probably sit in with the board. They're the ones that will see it. They won't be shared with other employees of the company. But obviously, further down, there are other agreements listed there that do indeed relate to other departments. And so, banking and financial agreements will be in with finance. The staff contracts that we talked about, HR contracts, will sit with HR. Renting your offices, various other legal agreements like that will be in with operations. The sales department will have warranty agreements and end-user license agreements and sales agreements and so forth. So I've listed a few of those there, for example. The other thing, NDAs, so we mentioned non-disclosure agreements in the context of staff signing them when they're working in the company. NDAs are also used widely with other companies. So if you're collaborating with a company, if indeed you're licensing from the university and so forth, you will often put an NDA in place between the two organisations. And again, that's to help keep all this stuff confidential. It makes it clear what is secret and also the ramifications if it's let out. There's the couple of key things here is, one, you don't want to be a really bureaucratic company, but a lot of these agreements are really important. They're important. Obviously, you need a record that you've signed them. As to the liabilities that you've brought on yourselves as a company, but also, what are the terms that various people have signed up to. You need to be able to find them, so if things go wrong, they're there to be looked at. But also, if you do get an investor coming along, they do a thing called due diligence, which is where they want to see all the stuff that you've done and prove that you've got a license agreement or prove that it's not overtly onerous. So you need all these things available to provide for their research as well. So again, what will probably happen is they will all be dispersed in these various departments. You can imagine a sales department will be signing all things left, right and centre. And what you need to try and do is get a handle on it. And I think the best way to get a handle on it is early on. Get the sort of the way that the ethos in the company works when it's small, to follow a few straightforward procedures. And I have an example here where you can quite early on just start numbering the documents that you're using. Give your company a simple acronym like MICO, so something that you know is your company. So these are therefore documents that are originating from your company. Give it a company code, so UK, if it's UK-based stuff. And this is important because once you have a subsidiary in another company, in another country, you will almost certainly have a whole load of new documents originating from there. So simplistically, you have MICO UK, MICO US, MICO HK of Hong Kong or something. Yeah? And then simply have a list of documents, in this case, document number and the number, like 1, 2, 3, 4. SA, signed agreements and the number, or asset number in terms of physical assets and number. And the X.Y is the number and the version number, because things always increment in versions. You always end up with multiple versions. And then you've got a handle on everything, yeah? So as soon as you sign an agreement, you would call it 1.1. When you sign another agreement, it's 2.1. And you just keep an index of all these agreements. And then when you need to find them, you have them. And as long as everybody in your company starts to use that process at the beginning, it'll start to flow through. Version control, so NDA versions, making sure that everybody signed the most up-to-date version because you've suddenly realised something's changed that you've forgotten, yeah, and you put that in. In terms of revisions with legal agreements, that's really important. Sometimes things stand up in law because of the history in how they were written. So if you have gone to court and you're fighting over some disagreement, the signed document is obviously the most important thing. But if there's something in the way that that signed document evolved to become the way it was, and you can show the earlier versions which showed the intent where you'd negotiated the price or whatever, then the courts may say, look, we can see what the intent here was from all your other agreement versions that built up to it. And they use that as evidence. So don't just throw away everything else. It's digital. It's free to keep in the background somewhere. Summary really is IP. There's a lot of value in getting the IP protected. It's really important for a startup, especially a tech startup. Agreements, very important as to what's in them. So obviously they can be assets because they bring value to the company, but if you're not careful, they can bring liabilities as well because you sign up to something that you really don't want. And because obviously documents evolve, they're negotiated, people need to see them, you need to know what you've signed up for. Trying to keep organised so that you know where everything is helpful.